Good morning, friends. Today's discussion is basically surrounding introducing this Personal Data Protection Bill 2019, which will be the act when it is passed and is likely to be um, implemented across all organizations, both private organizations and government organizations. So all of us who are in some way handling personal data will be affected by this legislation, and we need to keep track of this particular law as it emerges. I am one of those persons who always try to be ahead of the event so that though the act will come after some time and then there will be time for implementation, we always feel that there is a time required for absorbing some new development, and we better use an opportunity to start studying earlier than when it becomes almost mandatory. The first, of course, thought which comes across in this kind of a forum is that whether this law, PDPB, is meant for people like us who are dealing with the technology. So, unless we accept that sometimes laws do become relevant for technologies, it will be difficult to appreciate how we need to devote our attention to this emerging law. Now, we all know that GDPR came in 2018. When it came, it was at one end, it was a threat to many companies in the sense that it increased the cost of compliance. Suddenly, they had to change the architecture of their processing, and quite a lot of disruption did take place. But at the same time, it was a big wave of opportunity for those who actually moved with the times and became GDPR compliant. Even today, organizations would like to get themselves branded as GDPR compliant because that will add to their marketability in the international market. This GDPR brought this concept of DPO, the data protection officer, into the top management in any organization. And to the extent that some of the existing people got redesignated as DPOs in certain cases, and in certain cases, new people joined an organization as a DPO and started imposing their views on others, there was some kind of a minor disruption at that time. But what is likely to happen now is a very big wave is likely to hit the corporates in the form of this Personal Data Protection Act. The question which all of us have to ask ourselves is, do we surf over this wave and rise to the top, or we allow ourselves to get under? Now, many of us also think that we have all been discussing about information security for decades, and we have our hairs are turning gray with all this experience. Now, what is new in data security? We always knew confidentiality, integrity, and availability, CIA principle. We applied it to the whole of data in an organization. Personal data was part of that whole data. So I am already protecting personal data. So what is more, which people are talking? This is a point which we need to keep on debating over time. But this domain of law, which people like us are introducing to the technology, people definitely you need to think, why should I at this age take a, sort of a responsibility to learn something which was not necessary for me so far? But the point you have to consider is, if you don't do it, will you be overtaken by others in your corporate career? It's possible that a good lawyer who knows some technology may become a DPO. Same way, a technologist, if he starts learning a little bit of this data protection law, this combination of technology and law could actually push somebody other than you into the higher echelons of career, and that is what all of us need to remember. Now, I'm definitely certain that most of you will have to think on this, whether whatever you are today, okay, will you be the same when the so-called data protection officers who come at the level of say reporting to the CEO or reporting directly to the board start interfering with your scope of work. That is the time when perhaps some of you will regret that you did not perhaps start as early as possible, and that is where people like us have been trying to make technology people take some effort to understand this data protection law so that you don't have reason to complain on a later day. See, when GDPR came in 2018, whenever we speak of new business, okay, uh, or even a new technology process, we are worrying about the GDPR risk. And our business people, when they go for business discussions, are often asked the question, are you GDPR compliant? Now, whether GDPR is applicable or not, this question is being raised. So sometimes our business people are able to answer that maybe for this particular business, GDPR is not relevant. But most of the time in business negotiations, GDPR compliance has become a sort of a mark of respect for the company, and so we try to do something on GDPR risk management. Now, similarly, you have also perhaps been involved in preparing what we may call as a DPIA, or Data Protection Impact Assessment, which is actually created by the technology department, but somebody called the DPO says, I will review it. See, many companies have avoided this conflict because the CISO himself has been designated as DPO, but you know that GDPR does not accept that common designation. In fact, at least in one case, a supervisory authority of GDPR held that the chief compliance officer acting as DPO is also a conflict of interest, and they imposed fine on that particular company. So if a chief compliance officer who is a legal person has a conflict with the role of a DPO, you can imagine that a CISO will definitely have a conflict with the DPO, and any organization which has designated a CISO as also the DPO will have to find a way of segregating these duties. In such a situation, DPIA is prepared by the technology department, and the DPO will start reviewing it. And if the DPO does not understand technology, then you have a difficult situation in the organization. Secondly, even though we are sometimes compliant with ISO 27001 and we are certified for that, so in terms of security um, posture, our company is well prepared, people still ask, are you GDPR compliant? It is different from ISO 27001. Of course, recently 27701 has come in, which is privacy related compliance structure, but that also is dependent on ISO 27001. Now, with all this development, a new law specifically to India is coming up, which is the Personal Data Protection Act. In one way, you can say this could be an Indian version of GDPR. Then obviously you have to check whether this will bring more headaches to us and whether there will be another round of audits from the PDPA India perspective, and will it be different from GDPR? These are the questions which you have to mull about, okay? And even if you are 27701, remember that 27701 was drafted specifically to be compliant with GDPR. So unless Indian PDPA is a mirror copy of GDPR, being 27701 compliant does not automatically guarantee that you are compliant with PDPA. My own understanding of the bill as it stands today is that this is much different from GDPR, though the principles of privacy are same. So privacy framework normally cuts across many laws, whether it is Singapore law or Brazil law or Dubai law or Indian law. But there are subtle differences which Indian Personal Data Protection Act brings, which in the compliance scenario, non-compliance will lead to a problem. Okay, so we should not assume that if we are GDPR compliant, we will be PDPA compliant. It is a very dangerous kind of thinking, and it is better to start with a presumption that let us start from zero and look at compliance of Indian law, irrespective of what I have been doing earlier in terms of GDPR. Also, in terms of applicability, you know that GDPR applies to EU data, PDPA applies to Indian data. There could be some areas where there could be conflicts of overlapping, you can say legislations that we will have to address as required in a given context. But generally, PDPA applies to a different set of data and GDPR applies to a different set of data. Therefore, being GDPR compliant does not mean that we are PDPA compliant. In fact, that is the reason why we have tried to come over ISO 27701 and started looking at a Personal Data Protection Standard of India, PDPSI, which encompasses the requirement of 27701 in the context of GDPR to the corresponding requirements under the Indian law. And also, I personally feel that most of the Indian companies have a unique situation where simultaneously we are processing data from EU, data from India, and maybe data from other countries. So we need a unified framework for compliance, which I can use simultaneously for complying with these multiple data protection laws. And that is why we have thought of looking at this PDPSI as a framework. With this kind of a thought behind us, we need to explore what lies ahead before this opportunity which has come in the form of PDPA flies past. And if we let it go and if we don't catch it, then we will be regretting after a particular period of time that somebody overtook me in the corporate hierarchy, and probably that is what we would like to avoid. Now, I would not actually like to discuss too much of clauses and provisions of law, but I will try to describe the impact of PDPB in terms of what a technologist can easily perceive. We will always have other opportunities to get into clause by clause discussion on a later day, for which of course we are also designing a separate training program that is for the future. But today we will try to look at this act and take a sort of a bird's eye view. Now, this PDPB, this is called PDPB because it is a bill. As you know that after this GDPR was introduced, in India also there was a clamor for Personal Data Protection Act. There was a Supreme Court judgment also, wherein we call that as Puttaswamy judgment, where they held that privacy is a fundamental right to an Indian citizen as per the Constitution. That was an entirely a decision which was relevant to the legal community. But in the process of that judgment, one of the judges made a clear remark that in today's context, privacy cannot be protected unless it is protected in the form of personal data, which is in the hands of data processing companies. That is, the information about a person which is held in electronic form. He said this is to be protected. If we don't protect that, we don't protect the privacy, because law defines privacy as a right in which a data subject or a person to whom we are referring to, an individual who is a natural person, he is told that you have got some personal data about yourself, and the law would like to give you a right. How much of your personal data you would like to share with some other person who may be a data processor, and how much of that you would like to hold it yourself. So this self-determination of how a personal data can be given to somebody else and allowed to be used or further disclosed, that right was what was declared as the privacy right to be protected under law. And since that particular activity was concentrated in the IT companies, the privacy protection from legal angle became also a subject matter of data protection. That is the reason why I normally use the term data protection, and we have also looked at FDPPI as an organization which is data protection organization. We by protecting the data, we are trying to protect the privacy. Of course, here we are talking of what is called personal data. Now, after this personal data protection bill came, subsequently the government has started a thought process on how to deal with non-personal data. That is, out of the whole data universe, you segregate something as personal data as defined under the Personal Data Protection Act, and then what is left is non-personal data. Now the government is thinking that we should encourage industries or organizations to actually unlock the financial potential which is there in the non-personal data, because non-personal data handling does not affect the privacy. So Puttaswamy judgment has got nothing to say about non-personal data. Then why don't we allow organizations to unlock the business potential? Now most of the companies are today doing business in personal data, and by passing this law, we are going to put a curb on commercial usage of personal data. At the same time, it is necessary to encourage the industries and give them an opportunity to make money, but not in the personal data processing, but in the non-personal data processing. Therefore, the government has already started a process for designing a new law called Data Personal Data, Non-Personal Data Governance Act. And exploitation of the opportunities which come under the Non-Personal Data Governance Act, for which the Chris Gopalakrishna committee has given its report, that will happen only if we know how to manage personal data as per the current act. That's why understanding this personal data protection bill and the act will also prepare our organizations for the next generation of data processing, which will be in the non-process, personal data regime. And that is why I call myself as a data governance consultant, because data governance includes data protection and perhaps includes the data business, which will be coming up on a later day. So that is where we stand today. And in this Personal Data Protection Act, therefore, the first thing it does is to define what is personal data. And once we understand what is personal data, we know how to break the data into personal data and non-personal data. And non-personal data as of now will not be part of personal data protection regime. And personal data we will discuss with reference to whatever other aspects the bill discusses. You must understand that India as of today has a law called Information Technology Act 2000, which was amended in 2008. And this act already has provisions for personal data protection. You have all heard of what is called the section 43 capital A, which says that any body corporate which is processing what is called sensitive personal data is required to have reasonable security practices and practice what is called due diligence, failing which that company will be liable for paying compensation to any data subject or anybody who has suffered a loss because a company did not follow reasonable security practices. That law is already there, and this Information Technology Act spoke of what is called due diligence. Due diligence is a concept in law which is very vague, but it says that the court has got a right to say that in this particular situation, a prudent person would do something like this. If you have not done that, then that will be considered as negligence or lack of due diligence. So due diligence definition is always open to interpretation on a contextual basis. So therefore, if you say today I am interpreting the section 43A or associated due diligence concept, the first thing I will ask a company is, are you aware that India is trying to come with a Personal Data Protection Act? You have to say yes. Then are you aware that globally GDPR is there, which is considered sacrosanct in personal data protection? You have to say yes. Then if I ask the question, as a prudent corporate entity, don't you think that the provisions of Personal Data Protection Bill is more or less a revision of what 43A expects as due diligence, because PDPB says that after this act comes into being, section 43A of Information Technology Act will be deleted. What does it mean? That 43A, what is today, is what is going to evolve as PDPB, and this is a seamless progression of our Information Technology Act into a separate, you can say, chapter called PDP Act, okay, Personal Data Protection Act. So establishing this relationship, I normally consider that PDPB 2019, which is a bill and not an act, is still a current due diligence parameter or a guideline for section 43A, and therefore this is more or less currently considered as a prevailing, you can say, business practice which should be adopted, without which companies will not be compliant with Information Technology Act. So what we are discussing today is due diligence under ITA 2000, which is there in the form of a PDPB, and when it is passed, it becomes a PDP Act in totality with all the provisions of penalties, etc. Okay, so that is how we have to look at this PDPB. Don't look at it as a bill which is there in the parliament, which will come later on. We don't know whether it will be passed. All that uncertainties are besides the point. We should consider PDPB as it exists now, without whatever amendments the JPC is proposing, as due diligence, and in an organization we need to implement this. So looking at that, now PDPB has got a chapter or two on definitions and applicability. That is the first and the most important aspects, because applicability determines whether as an organization the act is applicable to me, and second, what kind of data to which this is applicable. Both we have to see. Many times people will ask, is privacy applicable to companies? Now privacy law is applicable to companies from the compliance point of view. The same privacy law is applicable to an individual from the point of view of giving him the privacy rights. These are the two phases of the Privacy Act. The information about an individual who is a natural living person is the person whom we call as data principal in Indian law, and an organization which handles this personal data is having a set of compliance requirements under the law, and that company is what we call as a data fiduciary or a data processor. GDPR called these organizations as data controllers and data processors, and it felt that the data controller takes control of the personal data of a data subject, and it will try to use it and process it as per certain legal basis. Legal basis includes providing getting a consent from the data subject, and also to further use other lawful basis. But India has gone a step further, and it has defined the role of this data controller of GDPR as a data fiduciary. Data fiduciary means that it is a trustee. As a trustee, while you ask the beneficiary of the trustee, in this case the beneficiary of the trustee is the data subject or data principal, and To the best of his knowledge, he will give you some permission. Please process my data like this, like this, like this. But as a trustee, you are responsible to protect the rights of the data principal more than what the data principal himself is aware of. To understand this concept of data fiduciary, you must put yourself in the shoes of a guardian of a minor. Now, if your child says, I will touch fire, you as a guardian will say, don't touch fire. At that time, you don't say that it is his right to touch fire and learn. Okay, because you as a guardian are responsible to protect the particular minor from the point of view that he should not be harmed, and that person himself doesn't know what harms him and what does not harm him. Similarly, here the role of a data fiduciary makes the company a sort of a trustee, and it should know what harms the data principal or not, and ensure that the data is processed with the best interest of the data subject or data principal. So therefore, if I am developing a app and I want to take permissions, and I know that if I ask the permission for SMS, permission for ABCDE, that subject, without knowing what it is for, will say yes to everything and I can get it. But the role of a data fiduciary is that as a trustee, I should stand in the shoes of that person and then see whether that particular permission was required or not required. This important distinction is there in Indian PDPA, and it elevates the role of the data fiduciary to a level where you cannot depend entirely on the data subject's awareness. You have to create that awareness. That is why, in fact, GDPR compliance is easier, PDPA compliance is much more difficult. So we have to look at that applicability. Applicability comes with the understanding what are the exemptions. Then once we understand the exemptions, then we can get into discussing what are the obligations which the Act expects a data processor or a data fiduciary has to do. And in all these privacy laws, there is something called rights given to the data subjects. So what does Indian Data Protection Act gives? That needs to be understood. Children, normally, that is, children means we are talking of minors. There is a separate provision. We have to understand what is that. Then from the industry perspective, whether personal data for processing can be transferred out of India, that is an important aspect to understand. Then data breach is there in every data protection law. We must understand what is the data breach, when it should be reported, to whom it should be reported, etc. Then when we talk of rights of data subjects or the data principals, Indian law says that it is a responsibility of the organizations, that is data fiduciaries, to provide a grievance redressal mechanism. By law, a grievance redressal mechanism has to be implemented. Now, when we say grievance redressal, it does not stop at providing a help center, a call center where there are people to answer technical queries. That is not sufficient under PDPA. You have to have a person who understands the legal aspects of a grievance and then escalate it to either an ombudsman in the minimum or to a level of mediation and, if possible, arbitration. Of course, the law itself provides for certain legal processes called adjudication and appellate tribunal. But below that, companies are required to put in place certain grievance redressal mechanisms, which is different from what you have been doing today in terms of the help center. And correspondingly, the incident management system which you are managing today will have to be revamped to take into account the requirements of the law. The law also talks about penalties, and taking the cue from GDPR, this law also talks of 2% or 4% of the global turnover in rupee terms. Of course, it may be 5 crores or 15 crores, but whichever is higher is what the law defines. So 4% of my company's global turnover will be at stake if I am not being compliant with the Indian PDPA. So that is what we need to remember, and that is what the managements will have to keep in mind before say discussing whether there is a need to learn this law, need to comply with this particular legislation. There is going to be a separate regulatory authority, so that unlike the Information Technology Act, where the act will only be invoked when a complaint is lodged by a person who has suffered a wrongful loss, and the authority for that is an IT secretary who is an adjudicator, who is generally so overworked with his regular activities that he does not want more cases to be brought into him. Uh, Therefore, the absence of a regulatory authority dedicated to the cause of Section 43A was a lacuna in Information Technology Act, but that is being addressed now by setting up a regulatory authority which will have a chairman and 6 other members, representatives from law, representatives from technology, and all kinds of expertise will be there, and that will have certain quasi judicial powers. Under this regulatory authority will be an adjudicator who will be taking views on penalties. So this whole infrastructure of personal data management is coming up in this bill. We will get into questions a little later. Let me go through a few more slides just to give you a perspective. Then we will get into the discussions. Now, in terms of applicability of PDPA, one thing we recognize is that all types of entities, government, commercial and non-commercial, educational institutions, trusts, societies, Section 8 companies, they are all coming under the provision of this particular act. CIO association, if it is registered in any form, will also be coming under this. Now, but it applies to personal data. It does not apply to non-personal data. It does not apply to anonymized data, which is data which perhaps was born without any personal identity, or it was once a personal data, but we have anonymized the data in such a manner that it is irreversibly the identifications are removed, and such anonymized data along with this non-personal data is outside the provision of this act. So personal data, irrespective of the type of organizations, the applicability of PDPA comes in, provided the data is collected in India or disclosed in India, shared in India, or processed in India. So this is one category of activities where the activity is in India, activity involves personal data. So irrespective of the organization, that comes under the applicability of PDPA. Now, of course, it applies to government, fine. Now, when it comes to entities which are not present in India, that is the foreign companies, these companies have got two kinds of activities. One is, though they are foreign companies, they may be collecting, disclosing, sharing for personal data in India, in which case obviously this law will be applicable for them. And sometimes they will not be perhaps only they will collecting the data, but sitting somewhere else, they may be actually running an algorithm or something like that for processing the data, doing some profiling of Indian persons, and that also, though they don't have an office here or anything, or they don't even disclose anything, they only run a technology background there, that there is perhaps a cloud-based application, and everything is done in the cloud, and nothing else is being done. But as long as they are profiling the Indian people, then they will also be considered as coming under the provisions of PDPA. Indian law, of course, has made a small distinction in the sense that if there is a foreign company and it is processing only data of foreigners, obviously we don't have much stake in that. So Indian Act actually provides for exemption of processing of personal data by foreign companies if the personal data belongs to the foreign companies, foreign citizens. But of course it is through a notification, but that provision is there. Now, one of the key aspects of our act is that Indian Act does not allow an organization to simply declare that it is being compliant or they are following privacy by default. We say privacy by default is necessary and you should have a policy for that, and you should reduce that policy into writing, and that privacy by design policy should be submitted to the data protection authority and get certified, and that PPD policy may even be made public. This is exactly similar to the way public companies who want to raise funds from public are mandated to issue prospectus. So here the PBD policy is the prospectus which a company has to issue, saying that, dear friends, that is the data subjects of India, I want your personal data, I want to process it, but this is the condition under which I want to process. Please hand over your personal data, I want to collect it. That request for collection of personal data has to be done through a written PPD policy registered with the Data Protection Authority. This is one of the biggest challenges, because writing down the policy, which consists of managerial, organizational, business practices required to anticipate, which is a risk assessment, identification of the processes, avoiding harm to the data principle, to put it down in writing itself is a big challenge. Then, of course, what are the obligations I am undertaking? What is the technology I am using? What is my legitimate interest? How am I protecting the rights of the persons? All these things are to be part of the privacy by design policy. And if you can create that privacy by design policy for your organization, you would have actually passed through the test of PB, personal data protection compliance. When we come to the data protection officer, please remember that data protection officer by law is required to monitor the data processing activities in an organization. Monitoring means he will, of course, keep advising the company, which means he will keep advising even the CISO, CIO, or CCO, whoever it is that, and he will provide advice on how to DPIA will have to be perhaps done. You might have created a DPIA, he may reject it, he may say, I will not be able to get it through the DPA, so you will have to revise your DPIA. He may even have comments on the privacy by design policy, the processes you are using, and he may ask you to re-architect your entire technology process. That much of power is available to him. And of course, he will keep all records, which he will perhaps share with the Data Protection Authority, because he is the designated person in the company to provide assistance to the DPA, which is a legalistic organization. So one has to be very careful about what DPO wants. If DPO has asked you to do something and if you have not done it, he may perhaps tell the DPA that he tried his best and it has not been done by the technology department. So the, any of the non-compliance, DPO may become a whistleblower. So one has to be very careful about it, because that is the role which the Act has envisaged. He will also be acting as a point of contact for data principals. So all complaints will lodge from public will land with DPO, and he is the person who has to manage the relationship with the legal authority, and therefore internally he will have enormous powers to deal with the other people, and that is why we say this post is very near the board, and that is why CEO also has to ensure that a proper respect is given to the DPO. Now, as an organization, what are the responsibilities? One, we can call it by one single name called accountability. Accountability includes designation of a data protection officer. Accountability is privacy by design policy, having transparency, having security safeguards. This one element covers all your ISO 27001 with reference to the personal data, but all other things are additional. That is why we say that compliance to Data Protection Act is much more than 27701. Of course, 27701 does add some of these aspects like privacy by design, but not as a policy to be submitted, something as a technology practice, then transparency. All these things are there in ISO 27701, but grievance redressal mandatory is not there in GDPR. privacy by design policy approval is not there. Some registration of significant data fiduciaries is not there in 27701. So maintenance of records will be different, because in India you have to calculate what is called data trust score, which is not part of the 27701. So therefore, there are certain things which are different when you are talking of accountability to Indian law as compared to accountability to GDPR, and therefore there is a need for us to look at something different in compliance of Indian law. Grievance redressal is one. Children's data, sometimes it is different because the age of minority is different in different countries. Cross-border transfer, as of now, there is not much of a restriction in India. We have to see whether any further changes will be made when the JPC submits its final report. Penalties, as I told you, 2%, 4% is there. There is also criminal punishment in a very limited way, which is again not there in GDPR. Now, because of this difference, the question of trying to fit a square peg in a round hole, even if it is possible by forcing it, is not recommended, and therefore we are recommending a separate unified framework called PDPSI, which will have common controls and then will branch out into respective controls, provided your company has personal data of that nature. So if you are having personal data from India and the EU area and say Singapore, you will have common controls, about 40 implementation specifications. Some 8 to 10 implementation specifications will be exclusive to PDPA India. Same thing in a modified form will be there for GDPR in Singapore or Brazil or something like that. This is how the new PDPSI framework will perhaps make things different. But what we as professionals try to recognize is, one is learning about PDPA is unavoidable because it may become a law soon. It will, of course, be exciting, anything new. It will be challenging. It is an opportunity to break out from the current clutter in case you are bogged down in your career, and it could also cause a career slippage if you are ignored. Therefore, looking ahead, please be ready before the act comes into force. This is what I would like to suggest, and now I am open to taking any questions. Yeah, if you want, I will just take questions from the uh, list which is there. Ashish, can I go ahead?
Yes, yes. Thank you, Navi sir. The questions, I mean, you can read them or I can read it for you.
Yeah,
Uh,
I'll read it through. If I left out anything, you can ask me, and
sure,
then we will also take other oral questions from others. Okay. So the
sure,
first
sure.
question which has come up is, of course, how this is Charanjit Singh Bhatia. How the future structure for governance will emerge? Will CISO report to DPO or will they be independent? I feel CISO and DPO will be different, more or less parallel structures, and CISO will be, of course, an expert in information security. So when it comes to the information security of personal data, DPO may still consult the CISO, but final decision will be of the DPO. So therefore, DPO and CISO will have to work harmoniously. It's not anybody reporting to anybody. In fact, both will have to report to the CEO. And say in companies where company secretaries normally sit in the board meetings, because company secretary has a role directly with the uh, our compliance. Similarly, DPO will have a role for compliance. So DPO, even though he reports to CEO along with CISO, may be a common visitor into the boardrooms, because he is the external party, and any business decision, if the board is passing a new project, DPO is the first person who has to decide that there is a privacy related risk here. Okay, the business will look at it from the business point of view and sanction a particular project. The technology feasibility would have been seen, But DPO also, right at that level of acceptance of new business, will have to be consulted. So therefore, he will report to the CEO perhaps, but he will be having a very important say in board decisions. Okay. Now, does WhatsApp group created by employee of a company also come under the purview of PDPB? Now, the question you have to ask, this is Rajesh Srivatsap. Okay. Uh, now, now here you have to see who is collecting the information, personal information. Now, if personal information is collected by an individual, that is a natural person, for domestic purpose, it is considered to be outside the provisions. Now, here you are talking of a common group. Now, who is collecting the information is a question. Now, is WhatsApp collecting the information? I don't know whether it will be appropriate to consider WhatsApp needs your personal information other than your profile. We are always discussing the privacy policy of WhatsApp, and we are unhappy with the WhatsApp privacy policy for a different reason. So WhatsApp, to the extent that it has access to personal data, has got its own liability. Now, when you create the WhatsApp group as a company for your employees, that also comes under PDPB, in the sense that employees are always covered by personal data, except that Indian law provides lot of exemptions, at least from consent, with regard to employees. For example, anything related to recruitment, termination, assessment, internal fraud detection. In those circumstances, an employer is allowed to collect personal data without consent, in the sense that some processing is possible without the normal restrictions of a which is applicable in personal data protection regime. Now, the WhatsApp group, what is the purpose for which you have created? If it has been created by the employer for its activities, like handling personal data of employees in their normal scenario, this also becomes one like that. If it is a private group, then the private group, whoever creates it, the creator of the private group and the admin of that group should look at what is the purpose for which they are collecting the information, and if it is for personal reasons, personal purposes, domestic purposes, then you may not be covered under PDPB. But if it cannot be classified as collection by a natural person for domestic purpose, then it comes under PDPB. How exactly it will impact? We have to look at the exact scenario. Now, if it is sales or CRM, then it is part of the responsibility of the organization. Here you may have non-employees also, so you may collect customers information. Definitely it will come under PDPB. Okay, that is for Ankush Garg. Wishing someone on birthday. Okay, now the cause of action is with the birthday boy, okay, or the girl. Okay, if that person asks, how did you get my birthday, then you should be able to say that at least it was available in public uh, space. Indian PDPB provides some exemption for public data. GDPR doesn't recognize that much, but Indian PDPB will recognize the availability of information personal in public space. But you must be able to identify the source from which you got the information. If you can say you got it from public space, then there is not much of a, I mean, I can say cause of action for the person to whom you wished good luck or best wishes. Otherwise, it is possible for him to exercise what we call as right of access. He may give a counter question to you. Please tell me where from you got my data and whether I have given you consent to use my personal data, like date of birth. The onus of proving that you had consent is with the company or the recipient or the user of the data, and therefore it will be necessary for him to prove. Maybe you can take a defense that there is this is a purely domestic purpose. Say the question of domestic. Now tomorrow it will go into jurisprudence. Does wishing a birthday for a friend, is it domestic, or there should be some kind of a blood relations? So this is a point which nobody has discussed as of now. Perhaps from jurisprudence point of view, if you ask me, I will say that this kind of a birthday greetings amongst friends circles is more towards a use by a natural person for domestic purpose, though there is no domestication of this friendship, but still that has got some kind of a relationship. Courts may accept that it is a personal use, but otherwise there have been many instances where companies have sent a marketing message to somebody and the person has retorted back saying, where did you get my information? And if somebody wants to be difficult, even that person to whom you wished your birthday may come back and ask a question, and then you have to at least answer it. Okay. Anonymous attendee, how would you term personal data for blood samples collected by HR? Now, this is a sensitive personal information, but HR has got a right to collect certain information provided they justify it as a legitimate interest. So probably there will have to be a proper documentation of the need for such data. There is something called legitimate interest. There is exemption for providing benefits of employment. Now, you suppose, let us say, I document saying that I want to give an insurance to all my employees against some disease which can be identified by the blood sample test. Okay, so that's a legitimate interest I have to build into my policies. I have to do it faithfully. Because anyway, collecting blood samples, I am not going to use it personally as a HR manager. But if I am intending or to give a benefit to the employee, and that provision of the benefit requires this information, that is one of the grounds for which we can collect such information. Wherever possible, inform the employee, make him understand and take it. Otherwise also you can try to build a policy and build legitimate interest to that. Okay. Navneet, data trust score. Data trust score is a measurable parameter of how good is your compliance. Okay, that has to be done by the data auditor. It is mandatory in India to have annual data audit, and that data auditor, at least in the case of significant data fiduciaries, may evaluate the compliance by assigning a score, like your credit score which a CRISIL gives or a ICRA gives or a CIBIL gives. The data auditor will give a score, and that is called data trust score. As of now, uh, we don't know whether it will be made mandatory or it will be optional, but once some 10 companies start giving out their DTS scores, then the 11th company which is not having the DTS score, people will ask, why are you not giving DTS score? Maybe your DTS score is lower. So perception of data compliance, tomorrow the competition will be on the data trust score, which will become more or less mandatory. uh, Now, what is the duration cost avenue for learning and certification of pdpb for DPO role? Of course, these different organizations may have different way of doing it. I can only talk about FDPPI. FDPPI has formed a 5-module program. One is legal knowledge of Indian law. Second is legal knowledge of global laws. Third is data audit skills. Fourth is technology related to data protection, information and skills on that. And lastly, behavioral skills required for a DPO. So 5 modules we have created, out of which 3 modules have already been rolled out, and the other 2 modules we will be doing later on. So that will be through 5 different modules. So that much of time is required, and there will be examination, certifications, kind of a thing. Other organizations may develop their own systems. There may be some organizations which may say, pay me 1 lakh, I will give you a certificate. That is open to some organizations to decide whatever they want. But FDPPI makes it mandatory that you should sit through a training program, even if you are closing your ears, which we cannot find out. But a documentation of having attended the training program and evaluation of an online examination is mandatory for FDPPA certifications. Others may choose their own norms. Okay. Now, Arun Gupta, is this likely to become part of class 49? Yes, I think so, because when you are giving out a financial report, you are talking of risks. In fact, I have been vehemently talking about ITA 2008 compliance as part of class 49 requirements, because the risk, legal non-compliance risk, translates into financial losses, like the possibility that some kind of a penalty may be imposed on you affects financial health of the company. Therefore, it should be part of this class 49 declaration signed by the CFO. That is where you may have to even take cyber insurance to cover the liabilities, and then at least say in the balance sheet or the annual report that you have made a risk assessment, you have taken mitigation efforts. Beyond that, you have also taken a cyber insurance that is part of the class 49. I mean, whatever disclosures are required. Now, Vikas Sharma, if there's a data breach, who is responsible, DPO or the CIO? Now, in the case of significant data fiduciaries where DPO is a mandatory position, DPO will be accountable. Now, liability will be that of the company. Now, within the company, it is always possible for the organization to have an internal inquiry and say who was responsible and take internal disciplinary action. But outside, the organization is liable for data breach, and accountability will be with the organization. Okay. Is it going to be a regulatory requirement for appointing DPO? What should be the qualification? Is there certification course? Now, that is Shweta Shivatsa. Now, there is a regulatory requirement, particularly for those who will be classified as significant data fiduciary. Significant data fiduciary could be any organization which, based on the level of activity of personal data processing, the Data Protection Authority may say that this is required. DPO, it is a significant data fiduciary. And there is also organizations which it is not necessary that they should be handling only sensitive personal information. Even companies which are having non-sensitive personal information, if they are having sufficient volume of business, then they may be coming under the significant data fiduciary classification. DPO is essential for that. Ashish, I am exceeding the time. I have no problem, but you take care of the requirement. Okay.
Yeah, you can continue. I think, yeah.
Navi sir, I think we are all enjoying it and we are all here. So please continue.
Okay, fine. So that was one of the questions on that DPO. There were two sub questions. I forgot what are the sub questions. Which will, if it comes back, I will again talk about it. DPO qualification. There is no specified qualification except that there he has to be, functionalities are defined, functional responsibilities are given. So whoever gets that function, I mean skill sets to meet that, that will be the qualification. There is no other definition as of now. Now, certifications, as I told you, FDPPA is the first organization in India which has started giving out certified data protection professional certifications. What we have done is we have based it on the PDPB with an assurance that when the act comes, if there are any changes between the bill and the act, we will give a free, you can say, bridging sessions, so that nobody should feel that they took a training earlier than when the act came, and now people say 89 amendments will be there. Doesn't matter if 89 or 100 there is there, or if the entirely new act comes, we will repeat the program and ensure that required skills will be there with the particular persons. We will have the examination and other things, which, as I told you, 3 modules we have rolled out. 2 more modules are still due. We will do it later on. So that is the only certification program I am aware of in India, because initially people were telling that the act has not come, why should we have certification programs? But we went ahead and started doing that. Now, actually, over a period of 1 year and 2 months, we have provided certificates to nearly 120 people, and another 20-30 are in the pipeline now. So before the DPA comes, we will be having the experience of training DPOs. So we hope that will stand in good stead for us. Subsequently, others will also come. Okay, so you have to make a choice of where to go based on whatever requirement you have. Okay, now when data compromise is due to a bug or limitation of software solutions, uh, share the lab. So this is the reason why whenever, this is Arun Gupta, whenever you buy a software, you must have a fixing of responsibilities for zero-day vulnerabilities. Okay, indemnity should be there. I don't feel that any organization should be able to sell, say, certain products which are uh, below certain quality. Okay, so that is something which you have to ensure that you take care of it. Otherwise, it will be the user who will be responsible. For example, you take the Uber car accident in which a person was killed. The prima facie Uber is responsible. Now Uber can go back and say some component failed or something like that. That is between one data controller and the data processor and the software buyer and the software supplier. It has to be contractually determined who is going to be responsible. Another anonymous attendee, how it is described personal data storage and processing outside India. Say PDPA 2018 version had some slight stringent provision saying that you must keep a copy of all personal data transferred out of India. Now, in this current version, which is called pdpb 2019, there was a dilution. The dilution is that in the case of non-sensitive personal data, there is no restriction for cross-border transfer. In the case of sensitive personal data, you must keep a copy in India and you should take the explicit consent, then you can transfer it out of India. In the case of what may be termed as critical data, there will be restrictions. So this is what is going to be the situation as of now, unless there is going to be any modifications in between the bill and what JPC has recommended. Okay. Most of the banking call centers asking for data of birth for verification. Now, this is something which the banks have to decide. These call center employees, are they full-fledged employees of the organization, or are they daily wages people for the contractor? If that is so, definitely this is a risk. So normally, I suppose some of the banks or call centers have a technology system where certain confidential information is not spoken out. If it becomes necessary, it will be input into the software without the knowledge of the recipient, and that will be directly going into the system. Like when you make changes in the PIN and other things, maybe date of birth also, you must start introducing that system that instead of calling out the date of birth, you should ask the person to punch the date of birth on the mobile or something like that. And that is the technology re-architecturing which will be required when PDPB comes into being. Okay. Ashish Verma, would bank and finance have access to customers' data? They will have, because they are in that business. Okay. But the responsibility for taking consent, responsibility for protecting, responsibility not to share it with somebody else, that will still be there. Okay. Rajesh Panchal, manufacturing environment where contract work is done. Can you enlighten the same on Aadhaar details? See, you have to see whether there is a need for collecting Aadhaar details for KYC purpose. If so, you can look at the virtual ID or this for new form of Aadhaar verification which government has introduced, which is offline Aadhaar verification. Then the risk will be less. Don't take the original Aadhaar data, because that is something which the risk will be infinite. Okay, loss of that risk is infinite. Whereas virtual ID, if there is a compromise, you can always notify all your customers and they can change their virtual ID, even if they have not changed earlier. You know, virtual ID can be transaction specific, but if somebody has created a virtual ID, used it for multiple transactions, at least like changing the password, you can tell him, please change your virtual ID. So I would recommend every organization to immediately stop using or processing original Aadhaar IDs and go for virtual Aadhaar IDs, which is present now for last 2 years or even 3 years. But I don't think many of the companies have done it. This is the time to change their system. How do we track the implementation of PDPB? How many mandatory controls to apply? Now, these are matters of detail, Mr. Bhatia, and in PDPSI, we have got about 12 standards and 50 implementation specifications. That 50 implementation specifications may have many sub-controls. So it may go beyond 50. Like you have got in 27002, you may have 114 controls. Here we have got 50 at the top level, and there will be sometimes more controls for each implementation specification. Okay, that is specific to the framework. Now, Charanjit Bhatia, again, what will be the impact of retail FMCG industry as ISO 27001 is already available? See, ISO 27001 you have taken for the purpose of securing information in general. There was no privacy related issues which was considered by the ISO auditor originally. So therefore, you have to have additional controls implemented for the PDPB requirements. Self-sovereign digital identity is, I don't know exactly what Mr. Arun Gupta talks about here, but if you are talking about PGP kind of a thing, it is not going to be good enough. Maybe digital signatures legally approved may be good enough. I don't know. I will have to discuss more about what you mean. Will it control the whistleblower activity? Whistleblower activity is definitely one of the strategies which you use for control, and it is part of our PDPSI framework also. Okay, friends, I think I've gone as fast as
Wonderful,
I
Navi
could,
sir.
but
I
still
think
exceeded the time. Okay, yeah.
thank you so much. You actually did my job also easy in terms of reading out the questions and answering. But in everybody's interest, I also have one or two questions. You said DPO is now going to be a different role in the organization than the CISO or compliance officer or CIO. Uh, would it mandatorily have to be an independent role attended by an individual, or it could be a shared role?
No, law doesn't say it has to be independent, in the sense that there is a
When I meant shared role,
no,
it
no,
could be,
that's
I'm
what
asking
law as it stands now has not mandated that it should be independent, which means that it says other duties can be assigned to the same person, but he has to be an employee. Indian law requires him to be an employee, unlike GDPR where you can contract it completely outside. Now here you should have an internal employee to be accountable. If you want, you can take the consultancy from somebody else. That is okay. Now, when you are allocating other duties to this person, how to avoid conflict is a challenge. Now, every activity of the company will have a conflict with the DPO. And secondly, DPO is to be at such higher level that you cannot give him some PR work or something like that. Okay. He
okay.
has to be given a responsible position. So big companies definitely will find it difficult to get it shared. They may have to have an independent person. Smaller companies, now I don't want to say anything specifically, depending upon the context. If they cannot afford, they can give non-conflicting duty. Okay. I don't know, right? At this point of time, I don't know what is non-conflicting. HR will be conflicting, IT will be conflicting, legal will be conflicting. So what is left? Okay, business, definitely it is conflicting. So there is very little non-conflicting business because DPO encompasses everything. Okay, yeah.
Understood. And in terms of, because each country's privacy law is independent of each other, is there a scenario where, in terms of penalty, a company can be penalized, multiple times in one particular case?
There are very strange circumstances in which it can happen. Okay. I don't know if you have half a minute time, I can give an example, but otherwise, see, in application, each law should be applied for the personal data relevant to that country. So, if there is an Indian data with company, GDPR should not impose any penalty for that. But let us look at a scenario where an Indian data is being processed by a German processor in Germany. Then, being in Germany, that is exposed to GDPR, and GDPR doesn't say that I will not take any action if you wrongly process personal data of non German citizens or something like that. It is silent. Okay, so there, if there is a leakage or something like that, if I want to go to that supervisory authority and make a complaint, supervisory authority may still consider that as relevant and he may impose a penalty. But because this German company is processing Indian data, PDPB will also be relevant. So that will be a strange situation where two things may come. Same thing in India, the other way, if a German company wants to process in India, Indian PDPB has a section 37 which says that this Indian company can get exemption from PDPB in case German's data is being processed on behalf of a German company in India. So Indian PDPB has thought of this kind of a scenario where an Indian company, which should normally be under PDPB, may be processing the data of some foreigner, and because of a processing contract, and there is a overlapping, and that is being anyway covered by that foreign law. Why should I bother about protecting that? So they have given that as
Right.
a protection, I mean exemption, but it has to be by application and getting notified, which means that the organization has to create a ODC kind of a facility, say that this division processes this particular data, I want it to be exempted from PDPB, it will be given.
Wonderful. And just the last thing, few of the people have asked that, you mentioned about 5 modules which FDPPI has developed. What is the duration of, finishing those 5 modules?
See, when we actually ran the program as a live program, each program was about 16 to 20 hours. Okay. And we spread it out on weekends. So it went on for 3 weeks, 3 weekends, something like that. But whatever we have already completed, we have now made that modules available as an online streaming video. So the entire 16 hours or 20 hours plus what we are going to have now another 20 hours, so about 50 to 60 hours of training, which was actually conducted for a live batch, is available now on a recorded mode. People can go through that. Now 60 hours, somebody may be able to do it in 1 month, another person may be taking 3 months. So it is at their self determined speed. At the end of each module, there will be an examination, online examination, they can take it. So this streaming module, yeah, there is no, the time, it depends on the user. They may do it quickly. Within 1 week, they can complete that one module perhaps and take the examination, but 15 days minimum they should keep, I suppose. Okay. Next 2 modules when we actually conduct, the live modules will definitely will have, even if it is 12 hours, it has to go to 3 weeks or something like that. So time schedule will be there for the live programs. Okay.
Understood. Thank you. Thank you.
One
And these
thing,
modules can be,
Ashish,
sorry,
can I
sir.
ask one question?
Yes, please, sir.
Mr. Navi,
Yeah.
there are companies who have, can say, plants and branches, or you can say, acquire companies abroad, okay, in 3, 4, 5, 6 countries. So, would they be requiring one DPO specific to, can say, India, and then having knowledge about all other countries, data protection laws?
See, they can have a DPO
Or,
for GDPR if you want it separately. DPO for PDPA. Now, PDPA says that he should be a resident of India. Okay.
okay.
GDPR doesn't
Mhm.
say that. Maybe DIFC also may say he need not be resident. So you can have an Indian DPO who is also looking at the GDPR. Okay, that's possible. Reverse may not be possible. So ultimately, when you have such kind of operations, you will have a team of DPOs. You will have a chief DPO and maybe DPO for other things, because the knowledge is so diverse. Now 100 plus countries wants to have data protection laws, and you cannot afford to confuse with one from the other. It is like language. If I am speaking in Tamil and I also want to learn Telugu, I also want to learn something else, I may use a Tamil word in Telugu and cause a problem. Okay. Likewise, if a person doesn't have a specialization, it will be a risk. So companies will have to take a view on that. But wherever laws have said that there is a DPO resident in the particular country is required, you have to manage that.
Okay. Thank you, Naveed.
Yeah.